All right, as to bond.
Mr. Bond, Judge, currently the defendant's bond is $500,000 cash surety. 21 years old. I don't believe he forms a flight risk. In fact, he had something before this court that he was on HIDA for, and he successfully completed all of the terms and conditions for the HIDA. So the court is somewhat familiar with.
I am.
And a $500,000 cash surety bond. And I realize we're dealing with some serious circumstances here, but that's still an outrageous amount. The purpose of bond is to assure his presence, number one, two, to protect the public.
All right, Mr. Callahan, you might not know this. I know there was we had a prior counsel on this before you. Mr. Woodyard had Mr. Overton's case, and NDS had to recuse themselves or take themselves off the case. We had a DSU, and Mr. Callahan, you and I have been practicing serious criminal law for a long, long time. Mr. Overton on the risk assessment tool scored a +10. I've never seen a +10. Have you? Have you? I've seen +3s, even a +5. But his risk assessment tool is a +10. And you're willing, if you want to look at that, Mr. Callahan, you can come on up. I've never seen a +10 ever.
I don't need to.
All right, I didn't think so. Bond is continued. He's certainly a flight risk, and he's definitely, based on the allegations here, as well as his criminal history, prior criminal history, a danger to him, to the community, and bond is continued. But Mr. Callahan, if you want to look at that DSU report, you're free to.
I'm good. Thank you.
Okay.
Well, you're Jeffrey Fanta on behalf of Mr. Moore, who is present by Zoom. Judge, this is time and date set by the court for an in-person hearing relative to Mr. Moore and, for a proposed bond violation. Addressing the in-person issue, Judge, Mr. Moore played me a phone message that came from the court that should have been, I think the court just called the wrong number, and left a message on his number indicating a hearing, but it was directed towards Ms. Butcher. And so he did not have knowledge that he was supposed to be here in person. Number two, I would ask the court, after talking to Mr. Moore, request the court, based upon the landlord-tenant matter that was before the court, I think last week or the week before, would request the court recuse itself and set this matter for a hearing before Judge Slavin tomorrow morning. And we would be prepared to address the violations at that time. And Mr. Moore will be here in person.
Okay, well, I want to address that. We can set this for the morning. I don't believe that that's grounds for recusal on this case. Mr. Moore was present. There was a landlord-tenant case. His conduct at that landlord-tenant case occurred in my presence in open court on Zoom and on YouTube. And I don't know that anytime someone in a case, behaves poorly in a courtroom, that I should have to recuse myself. I don't know that that's the appropriate remedy. I certainly believe I can be fair and impartial on this case. I certainly have concerns with the allegations of the bond violations, but at this point, at this point in time, I'm not recusing myself from this case. I don't think it's necessary or appropriate under the judicial canons for me to do so.
Judge, if I would request the matter be set for tomorrow morning, I'm going to be here. Mr. Moore will be here.
Okay. It should be in person.
He will be in person.
Okay. Miss Maudlin, I don't know what our day looks like. What's that?
The landlord tenant.
I have landlord tenant. It ends around 10. My second batch is at 10:30.
I'm here all day, Judge, so whatever.
Well, Miss Davidova was courteous enough to join us today from the prosecutor's office. This is not her docket. I'm guessing she's got another place to be tomorrow.
I do have court in the morning, Your Honor, tomorrow, but I can make like 11:30 work. I just circuit court sometimes is backed up.
I get it. Is that okay?
That's fine, Judge.
All right, Ms. Davidova, you're free to appear via Zoom. Ms. Butcher, you're to appear via Zoom. Mr. Moore, you're to appear in person.
Your Honor, before we go,
sorry, go ahead.
Before we go for the day, can the court inquire where Mr. Moore is presently?
My understanding is Mr. Moore checked in and told one of the clerks that he was out of state right now.
Mr. Moore is not commenting, Judge. He has a right to not say anything.
He's exercising his right to remain silent, Ms. Davidova.
All right. Thank you, Your Honor.
And Mr. Moore, just acknowledge that the hearing's at 11:30. I would like you here at 11 so we can talk, okay?
Mr. Moore, you're muted. Okay, I see a thumbs up, so it sounds like he understands.
Yeah, I've asked him to mute himself and not say anything, Judge, so that's a good, perfect response.
Okay, so Mr. Moore, we'll see you in person at the 23rd District Court. Your attorney is requested that you get here a half hour before that hearing at 11 a.m.
We need a good number for the complaining witness because it is the same number. The only number we have is the
Just for him.
Okay, and Miss,
I'll give you a second.
Okay, so Miss Butcher, I'm going to put you in a room. Can we just get it from Miss Davidova? And that way it's not on record. Yeah. Miss Butcher, I'm going to put you in a room with Miss Davidova. Miss Davidova, if you could just secure a good phone number for Miss Butcher, and then we can get that information from you. And that way you could just shoot it to us in an email, and that way it's not on record and on YouTube, okay?
Sounds good. Thank you, Your Honor.
All right, this is 240643, the state of Michigan versus Antoine Carter.
James Kazicki on behalf of Mr. Carter. After speaking with the prosecutor, we're going to set this matter for a settlement conference. Also like to address bond.
I have, he has a, what's the bond now? Oh.
60,000, 10%. Okay, so we'll set up with the settlement conference with the complaining witness to appear as Mr. Kazicki has to bond. Bond, I'd ask for a personal bond with a tether, Your Honor. He cannot raise the $6,000 to post a bond in this matter.
All right, well, he had like conditions of bond for an assaultive case, and the condition was that he not have any contact with the complaining witness. I would note that the defendant has prior convictions for firearms. And he was actually arrested at the victim's house when the neighbors are alleged to have called the police because of a disturbance at the one place he wasn't allowed to be. So he does not comply with court orders. He made a decision. He knew he wasn't to be there. He went there, and I am not modifying bond. It's an assaultive case. He's got a prior weapons conviction, and he had one thing he couldn't do, and he did it. And I believe that he's a danger to the community. Thank you. We'll get a date as soon as possible.
Thank you.
You failed to appear for a drug test on June 9th. How do you plead?
Guilty, Your Honor.
To the allegation you failed to submit to your, or you submitted a late PBT at 9:46 p.m. on June 9th. How do you plead?
Guilty, Your Honor.
All right. I'm going to accept the pleas as knowing and voluntarily given. Anything, Mr. Keys?
I did discuss the issue with him and, you know, kind of what the suspicions may be. And I think he's very understanding of why I would suspect what I'm suspecting. Did have him submit to a drug test today. The results were negative. This is his first violation in over 4 months, which is quite an improvement compared to where we were at, you know, 6 months ago. So, but I think he's understanding of the recommendation. And
yeah, DeJuan, the concern is of all the violations you could have, these are indicative of use. This makes me think you drank, right? Yes. So there's all kinds of violations you could have. You could be late on something. We didn't have any tests that would cover this period.
We did not, unfortunately.
What is he testing at right now?
He's on Navy for drug testing.
So how frequently?
2 times a week. approximately 2 to 3, depending on the week.
So Dewan, like I know you told Matt about some circumstances. I don't know if you've got documentation to provide. I am sorry, but you know, if we need to know if you have some documentation to support that.
Well, I explained to him that it's my second cousin, so I'm not immediate family, so I couldn't get from the hospital, but I am attending his funeral on the 22nd, and I could have this obituary.
Okay.
But
Dewan, this is just, you missed your PBT, you missed your test in a time frame like that. Like what, if you were me, what would you think?
using obviously, but honestly, I didn't have my vehicle. I didn't get back home till late. That's why I submitted the test when I got back home.
Could have called, just call or text.
But I didn't. I was negligent on actually even checking that color that day because we had tested, I want to say Friday, and I was going through all that stuff. So it was complete negligence on my behalf on checking the color. But I did when I got home. I made sure I submitted PBT.
Did you call Matt?
I did not actually, like I was telling him also, when I realized the color hadn't been called Tuesday, I kind of got like worried, like, why haven't I been called? So, but then.
Well, you should have called Matt and told Matt what was going on. If you'd asked for permission instead of forgiveness, we'd not be here and you would not be doing day in jail. Like that's the reality. All you would have had to do is say, Matt, something big is going on in my family. I can't make it today. Can I make it up later? Or I'm going to be late on my PBT. I'm not near my car. There is something besides me drinking going on. But instead you ask for forgiveness. And Dewan, we're way past that. We're way past this. Like this kind of thing should not be happening anymore. And I don't mean like life happens. It's not the test as much it is the lack of communication, you know. So 1 day jail, Matt will give you your report date. Okay.